Greetings, my fellow Americans. Today I'm going to talk a little bit about a subject that we raised in the last podcast. Normally I try to keep the podcast self-contained, but it was brought to my attention that there is really a large issue that revolves around the very subject we talked about last time, which was on the subject of unpublished opinions or memorandum orders that come out of the Montana Supreme Court and the reasons behind them. In specific, this issue deals with the subject of unauthorized practice of law in Montana. Now, under normal standards, should be self-explanatory. If you're an attorney or you say you're an attorney, you go out and you represent someone in court, or you do something in that capacity, you give them legal advice or counsel, you're an attorney, especially if you advertise yourself doing so or you accept money for those services. You're an attorney, or at least you're practicing. And, the state requires you to be licensed for that purpose. Now, keep in mind, I actually have a very strong opinion of lawyers and attorneys in the United States and how much control they actually have over our government. I think they are largely unregulated, even though they have a token practice and code of ethics in which they operate under. Nevertheless, I find far too often that those codes and ethics are skirted, they're not followed at all, and enforcement of them can be largely impractical because there's just no one who wants to go back and actually penalize the attorneys if they step outside these largely voluntarily compliant laws or standards that they're supposed to operate their business under. And of course, it keeps them not at all from being involved in government or politics. So that's another subject entirely, and I'm just going to leave it at that because I would sit here and I'd spend the whole podcast talking about that. Instead, I'm going to talk about something called the Commission on the Unauthorized Practice of Law. And what it basically is a commission that was set up in Montana under the Montana Supreme Court for the purpose of enforcing, as kind of like a government oversight committee, and largely a Gestapo-style organization that would just come in and basically direct you and tell you cannot do this, that, or the other because it's practicing law, and then they would actually take you to court and get orders and injunctions against you, and it was a mess. Aside from the fact it's obviously unconstitutional, what's really important is the definition of practicing law in Montana. Now, once again, we've already talked about just a few minutes ago what actually practicing law is and what it should be. Now let me read you what actually Montana Code Annotated Section 3761201 actually says. The practice of law is, quote, any person who holds out to the public or advertises as an attorney or who appears in any court of record or before a judicial body, referee, commissioner, or other officer appointed to determine any question of law or fact by a court, or who engages in the business and duties and performs acts, matters, and things that are usually done or performed by an attorney at law in the practice of that profession. If you do this, it is considered to be practicing law. Now, let me break that down for you because it's a very long statement and it's complicated on its face. Any person who holds out to the public or advertises as an attorney, which is pretty much what we just talked about, that's the standard of what an attorney should be. If you basically say you're an attorney, if you advertise to the public, if you take money on behalf of being an attorney, you're considered practicing law. Pretty standard, pretty easy to understand that. That's where it goes off the rails, because this is now where it gets into areas that are just so amazingly overbroad and overreaching and unconstitutional, it's insane. Or who appears in any court of record, doesn't say on behalf of another person, just who appears in any court of record, or before a judicial body, referee, commissioner, or other officer appointed to determine any question of law or fact by a court. So in other words, if you appear before any of these people, if you individually appear before these people, you're practicing law. Or someone who engages in the business and duties and performs acts, matters, and things that are usually done or performed by an attorney at law in the practice of that profession. So, if you say to your grandma, I don't think you should go into that reverse mortgage, you're giving legal advice, you're practicing law. If you want to write a contract with Jim Bob, remember Jim Bob from our other podcasts? Well, we're bringing Jim Bob back into this. I'm going to sell Jim Bob a car. I'm going to write a contract out, a bill of sale, and say, I'm going to sell you this car for $200, and you agree to accept this car as is. I sign it, he signs it, ba-ding, ba-da-boom, we sold a car. I just broke the law. That's what that says. I can't do that under Montana law Montana law says I cannot do anything that an attorney can do. And technically, let's face it, attorneys do a lot more than just practice law and do things of legality. The area is so broad, it could literally include if you go to lunch at 12 o'clock because an attorney at law normally and routinely goes to lunch at 12 o'clock, you are practicing law. That's how broad that law is. It literally says if you can show me an attorney who does this in the normal course of their profession, and that is something someone else is doing, that's practicing law. I mean, it is so overly broad, it's insane. And that's what the Commission on the Unauthorized Practice of Law was enforcing. It was enforcing the standard that literally anyone, regardless of whether the law said you could practice law separate or do legal acts of legality separately, or whether the Constitution of the United States gave you the right to go to court and plead your own issues and appear in court and do all the legal things that individual citizen can do. In Montana, it's illegal. You have to have an attorney do it for you, because that's what that law says. And I've read it directly to you. I didn't make anything up. I didn't paraphrase it. I read it directly to you. You can look it up. MCA section 3761201. It absolutely is insane how overly broad it is. So here's what happened. I'm going to introduce you to a gentleman named Jerry O'Neill. Now, just pure disclaimer and up front, I know Jerry. Jerry and I do not always see eye to eye. We often do not see eye to eye. We don't get along on a lot of issues. We're civil to each other. We don't sit here and throw rocks at each other when we see each other in the street. At least I don't think he's throwing rocks at me, and I'm certainly not throwing rocks at him, so let's just assume that that's what's going on. But even though we don't get along, and even though it's not an issue of something that deals with hostility or anything like that, and like I said, we are civil to each other when we speak to each other, he saw my podcast yesterday. It's been reported to me through third person that he saw it and he approved of it and he liked it. And the discussion turned to the idea through this third person that this is exactly the kind of thing that the unpublished opinions deals with. And this is something that the Montana Supreme Court is actually using the unpublished opinions, memorandum opinions, to actually enforce. And Jerry O'Neill, knowing that the subject dealt with him directly, gave his thumbs up. Again, this is third person. I'm being reported to it through a third person that Jerry O'Neill has actually said he endorses me bringing this idea and this discussion forward, and so therefore here I am. That said, let's go ahead and talk about what I want to talk about, and that is a case called the Commission on the Unauthorized Practice of Law versus Jerry O'Neill. And you can look it up. It is 147 Pacific 3rd 200, 2006. Pacific 3rd, by the way, stands for Pacific Reporter, 3rd edition. It's just an abbreviation. It was a 2006 case. Jerry advertised himself, and interestingly enough, continues to this day to advertise himself as an independent paralegal. He listed himself in the attorney section of the newspaper. He did not identify himself as an attorney. He doesn't say Jerry O'Neill, attorney at law. He said Jerry O'Neill, independent paralegal, meaning he was independent of any law firm or legal company or LLC or anything like that. And in the course of doing so, he offered his services for the purposes of preparing contracts, wills. He represented people's interests in court, gave them legal counsel, advice, direction on what to do. He had them sign papers to recognize that they were doing so, knowing full well that he wasn't a practicing attorney, and that they basically were taking his counsel, as is. Well, the unified judges in our county, Flathead County, where he operates out of, by the way, he's out of Columbia Falls, Montana, and is part of Flathead County, wrote a letter to the Commission on Practice complaining about his practice, his independent paralegal practice. And then there were some other complaints floating in. People were complaining about the Yellow Pages ad being listed in the attorney section. People were complaining that he was going to other jurisdictions, other places in the state, and representing clients and giving them legal counsel. And that he was basically, even though he wasn't soliciting himself as an attorney, he was in fact practicing law. The Commission came down and smacked him with a civil complaint in 2002, and which was eventually led to the district court in 2004, I believe, actually coming down and issuing an order against him, forbidding him from practicing law, forbidding him from, in any manner, shape, or form, continuing his business as it was. He appealed to the Montana Supreme Court. The Montana Supreme Court upheld it. He failed spectacularly across the board. Didn't succeed on a single point. Mind you, he should have, but Montana Supreme Court wasn't going to let someone come in and practice law when they've gone through such an extensive effort of not allowing anyone to practice law or do anything remotely legal. So it's no surprise the Montana Supreme Court upheld the district court's decision. But nevertheless, he lost spectacularly across the board as far as the paper is concerned. Well, someone took his case, whether it was Jerry himself or someone else entirely, contacted the Federal Trade Commission, who's responsible for enforcing the antitrust laws of the United States, and specifically reported that Montana was violating the Sherman antitrust laws, specifically the Sherman Antitrust Act of 1890, and specifically using Jerry's case and situation as a litmus test, saying this is an example of how broad and overreaching the Montana Supreme Court is, how Montana is overreaching and basically monopolizing the practice of law through government oversight. Well, that did get the FTC's attention. They came in and started asking questions. They started sending inquiry letters. They started trying to reach out and find and do a probative investigation from Washington, D.C. Now, remember, as I've said in previous videos and previous podcasts, that Montana isolates itself as a chink of armor around itself that is, every time a federal office opens, they elevate someone from within Montana to hold that position, whether it be a judgeship, a AG spot, whatever. If there's a federal office in Montana, a federal agency, I have yet to locate a single federal agent who was not elevated from within the state of Montana, who had a pre-existing loyalty to Montana and its corrupt system. So this chink of armor, this shield of armor that exists around Montana, this federal oversight that's supposed to exist, doesn't exist because it is actually the chinks of the armor, the individual links, are individuals who are already from within Montana, and therefore they're loyal to Montana, and therefore they enforce the standards of Montana and ignore any real, true, independent oversight. So now here's the FTC coming in saying, oh, we've got a little chink in the armor here because we're going to start asking questions about how you do this and how you're monopolizing the practice of law in Montana. Well, Montana panicked a little bit. They basically started asking questions. They started realizing that if they get in through this one chink, this one break in our armor, it's going to cause a cascade, because you start asking questions about the Commission on Practice and their enforcement of the laws, the enforcement of the unauthorized practice of laws defined in Montana. It's automatically going to breach into the corruption of the courts, the corruption of the prosecutors' offices, to the various misconduct of the state officials. It's just going to be a cascade effect all across the board. You can't let the federal government in even a little bit, because you let them in a little bit and they start asking questions, those questions will eventually lead to other misconduct and other violations of law and standards of civil right deprivation, you name it, across the board. The entire Great Montana Conspiracy will be exposed. And so the Supreme Court in 2009, Montana Supreme Court, put together what they called public comment period for the purposes of modifying the Commission on the Unauthorized Practice of Law. Now, keep in mind, I've sat in on a couple of their so-called public comment sessions that they've held. They're jokes. They don't really, they're there for purpose of show, for face. We are going to publicly solicit comment. We're going to have these town hall kind of interactive meetings where you can ask questions and find out, and we're going to take suggestions and everything else. It doesn't exist. I mean, I've attended them. I have literally thrown constitutional law at them at these meetings and been ignored. It is purely for face. It is there to make themselves look like they're governing, look like they're listening for input, but they ignore whatever they hear. It is very much largely yeah, I guess we can look into that, sure. And that's all you get. You never hear anything more from it. You never hear back from them. You never hear any kind of follow-up, and the issues you raise are never brought up. These are really just no more than, let us do our bare minimum to make it look like we're doing our jobs. That's what these commissions, these little public comment issue or little comment meetings actually end up being. But what they were basically doing, the entire purpose of this, was not to find ways to modify it in and of itself, but instead, surely to modify it, but not for the reasons they solicited the public. What they were trying to do was try to find a way to continue doing what they were doing and sidestep or work under the table and under the triggering level of actual monopoly. Could they continue to operate the Commission on the Unauthorized Practice of Law without triggering monopoly laws? Could they do it without triggering the violation of the Sherman Antitrust Act? And could they keep the FTC out? The answer was they couldn't. They could not operate this clearly unconstitutional body, clearly unconstitutional practice, run by a branch of the government that's not even constitutionally permitted to do what they're doing. Okay, and keep in mind that the wholesale damage this agency had done in its years of creation, its decades-long creation and existence, is just uncalculable. But nevertheless, the commission existed, and now they realized if they wanted to keep the FTC out of Montana, they had to throw the FTC a bone. And so they issued an order, and the order was dealing with the dissolution of the Commission of the Unauthorized Practice of Law. And on the surface, it looked fantastic. It looked wonderful. It addressed the problem. It said, we recognize that this is unconstitutional. We recognize that the court doesn't have authority to do this, that the Constitution gives power to the legislature to define what unauthorized practice of law is, and it gives that power to the executive branch to enforce it. We're not supposed to be involved in it. We have to step back. It seems on the surface to actually be a very legitimate effort to try to address something that's being done wrong and fix it. It's smokescreen, ladies and gentlemen. It is smokescreen, my fellow Americans. But before I go on to why it's smokescreen, let me take a step back and actually read you a paragraph from the order. And I'm going to read it verbatim, because it's going to talk to you about exactly how broad Montana's interpretation of what unauthorized practice of law is and what they were enforcing through this commission. In paragraph 6 of the order, it says, we conclude that the array of persons and institutions that provide legal or legally related services to members of the public are literally too numerous to list. To name but a very few by way of example, these include bankers, realtors, vehicle sales and finance persons, mortgage companies, stockbrokers, financial planners, insurance agents, healthcare providers, and accountants. Within the broad definition of Section 3761-201, remember, I've already cited that to you, it may be that some of these professions and businesses practice law in one fashion or another in, for example, filling out legal forms, giving advice about, quote, what this or that means, end quote, in a form or contract, in estate and retirement planning, in obtaining informed consent, in buying and selling property, and in giving tax advice. Federal and state administrative agencies regulate many of these professions and businesses via rules and regulations. Federal and state consumer protection laws and other statutory schemes may be implicated in the activities of these professions and fields, and individuals and non-human entities may be liable in actions in law and in equity for their conduct. Furthermore, what constitutes the practice of law, not to mention what practice is authorized and what is unauthorized, is by no means clearly defined. Yeah, it's so broad. Back to the quote. Finally, we are also mindful of the movement towards nationalization and globalization of the practice of law, and with the action taken by federal authorities against state attempts to localize, monopolize, regulate, or restrict the interstate or international provisions of legal services. End quote. What this says is broadly that practicing of law as defined by Montana law, as defined and instituted and enforced by the Commission on Practice, is clearly too broad. That's as far as they go. This document, this order, literally accomplishes almost nothing. The only thing it actually does is it dissolves the commission itself. It does not stop the law, repeal the law, call for modification of the law. It doesn't stop people from acting under the law or enforcing these standards. It simply says we're not going to have a flagship commission enforcing this anymore. They're still going to enforce it. Of course they're going to enforce it. They're going to keep doing it. But we're not going to have this flagship entity that the FTC is looking into. We're going to dissolve it and get rid of it so the FTC doesn't have a target anymore. They went from being in the limelight to working in the shadows. And which is often what happens when you deal with conspiracies. People work behind the scenes rather than open in the air and so long as somebody starts asking questions and the right people start asking questions, then they start taking a step back because they know what they are doing is wrong. That's the big catch here. It's absolutely wrong. They know it's absolutely wrong. But they were still doing it anyway. They only did something about it and made it look like they were doing something significant because they got caught with their hands in the cookie jar. And they were afraid that if they came in and started looking into this issue, and they started poking around too far beyond this issue, it was going to cascade into other issues within the Montana Supreme Court itself, possibly the unpublished opinions and the memorandum opinion issue within the state, possibly into what particular rules are being enforced, what businesses are they suppressing, who's taking benefit, where are the corrupt officials at. It's just the entire Great Montana Conspiracy would be exposed. And so that's what Montana didn't want to happen. So using what the Sherman Antitrust Act of 1890, and I'm going to quote to you actually what that law says. It says that, what it specifically does is it outlaws, quote, every contract, combination, or conspiracy and restraint of trade, end quote, and, quote, monopolization, attempted monopolization, or conspiracy or combination to monopolize, end quote. So any agency, government, business, individual who seeks to monopolize trade, monopolize or take sole control over an industry or sole control over a business, it's monopolizing, and it's forbidden under the FTC rules under the Sherman Antitrust Act of 1890. The complaint that used Jerry O'Neill's case as an impetus was defined around the idea that Montana, now whether it started out that way or not, now I need to clarify that, whether the complaint made to the federal government actually started as a complaint of the Sherman antitrust laws, there's no way for me to know. But what it ultimately did was it got the federal government or someone within the FTC to recognize that it was clearly an issue, and they started making questions, they started making inquiries, and it prompted Montana Supreme Court to issue this order. And by the way, you can look up the order. It's cause number AF09-0068. So if you ever want to look it up, there it is. But all they did was use this to prevent federal oversight. They sought their public comment. It was a joke. They've tried to find a way to modify it in a way that could avoid the federal oversight. It failed, so they issued this formal order very publicly saying they're going to dissolve the commission. It does cite the correct authorities. The Supreme Court had no authority to do this in the first place. It says it's not constitutional, it's not legal, and they can't legally restrict practice. However, whether O'Neill's responsible or not, the case that O'Neill had that was brought to the FTC's attention did in fact lead to this order. It was compelled simply to prevent the idea that the FTC from Washington, D.C. could actually come in and look into the practices ongoing in Montana. Mind you that since the time of the dissolution of this commission, nothing has really changed except it's not being centralized anymore. You still have the law. It still exists on the books. It's still being enforced. The judges are still telling people they can't do this or that because they're not attorneys, even though the law says in fact, we have in the Montana laws, we actually have the right to have what's be called attorney in fact, which means we have the right to write a power of attorney, give that power to somebody else to go into court and represent us. It's called an attorney in fact. It actually is in the laws. The court says, no, you can't do that. I personally tried to represent my grandmother's estate as a personal representative, and the law says very clearly that a personal representative can represent the estate in court. I went in to represent the estate in court. The court told me I couldn't do it because I'm not an attorney. And of course, it goes into Montana Supreme Court, and the Montana Supreme Court, guess what? You probably guessed it by this point because I brought it up in the beginning of the video, the beginning of this podcast. They use unpublished opinions. They use memorandum orders to reinforce what the commission itself was doing. So now not only is the Montana Supreme Court no longer just hiding it in a subdivision of the court, they're actually doing it themselves. They've got their hands dirty, but they're doing it through unpublished opinions, memorandum orders, so they're not published. You can't cite them, you can't reinforce them, you can't use them as any legal tender, and most importantly, they're not published in the National Registry. When you go to the Pacific Reporter that we talked about, Pacific Reporter, first edition, second edition, third edition, you do not see the unpublished opinions because they are unpublished. They are not published. They are ordered specifically in the language of the order itself. This order shall not be published and may not be cited. So they're basically using what they once did through the limelight down in the shadows. And they're saying, this is what we are doing. We're still going to enforce the same law. The same law exists. The same standard exists. We're just going to go ahead and do it now more covertly. And then when we are forced to act, we're not going to use a brightly lit room with people sitting in it around a room and calling themselves a commission. We're just going to issue memorandum orders through the court clerk's office. They can't be published other than on the court's website, of course, if you know what to look for. They aren't going to be cited. We're not going to openly and publicly declare we're still supporting this practice, but we are. We're just going to do it more covertly. We're going to issue orders and then have them be non-citable. Remember how I said in the podcast specifically dealing with unpublished opinions that this is how they hide their complicity, how they hide their criminal misconduct, is they hide their actions behind unpublished orders. And this is a perfect example of exactly how they do that, and they restrict the entire state of Montana doing this. Now, mind you, keep in mind, the real irony of this, even though Jerry O'Neill lost spectacularly in court, remember he just lost every single issue, was raised, was upheld by the Montana Supreme Court, no real surprise there. They've left him alone. He's still doing today exactly what he was doing when he got called before the Commission on Unauthorized Practice of Law. He's still acting as an independent paralegal. He's still got the advertisements. He's still doing everything he was doing before. And even though he has an order and an injunction preventing him to doing exactly what he's doing, he's still doing it. Why? Because the Montana is so worried that if they do it again to Jerry, he knows somebody in the FTC who's going to come back in, and this time they won't be able to hide. They dissolved the target that the FTC was looking at. But if they come in and enforce these rules against Jerry using the current subtle unpublished opinion angle, using the methods they're currently using to enforce this unconstitutional deprivation of civil liberty, that it's going to get the commission to pay attention again. They'll be back in Montana, and once again the fear of the broad range scattershot of everything that they've ever done wrong and that they're hiding is going to come out. So they left him alone. Jerry's getting up in age. They probably think eventually he's going to die, and they won't have to worry about him ever again. So he's been basically, for lack of a better way of saying it, and I don't mean any insult by saying this, he's been put out to pasture. Let him do what he wants to do. Let him go ahead and keep doing it. We don't care. He's one person. Meanwhile, we'll pass a law that says that the paralegal can't do this or that. In fact, the actual law specifically says that paralegals can't operate unless they are working under a lawyer. And you can look that up, by the way. It's MCA section 2510.305. It's a 2009 law that was instituted along with this restructuring and trying to find ways to hide from the FTC, to basically say that what O'Neill is doing is illegal. It says specifically that in order for a paralegal to do any services, he must be working under the supervision of a lawyer. Again, Jerry advertises himself as an independent paralegal. Therefore, he's not working under a lawyer, and he's got an order and injunction against him, preventing him from doing exactly what he's doing. But because he brought the federal government in, whether directly or indirectly, there's enough concern at higher levels of Montana's government that if they attack him again and he brings the FTC back in and points them in the direction of where they're currently operating, that they're going to once again be at risk of exposure. This is much like this order that they issued is much like the Emancipation Proclamation. Now, this is a little bit of history. Everyone recognizes the term Civil War. It really was a war between the states, and everyone today is taught that it dealt with freeing of the slaves. It is absolutely not true. It was taxation without representation primarily that led to the Civil War, and for 3 years it was fought, very bloody, very costly war. And in 1862, by late 1862, the South was running out of ammunition. the North was where all the manufacturing plants were, where the guns were made, where the ammunition was made, the bullets, the shells, everything. The South only had what they had stockpiled, and they were quickly running out after 2.5 years of war. They started, it was a very real possibility they would lose the war if it continued as it was. Well, England, who had a vested interest in maintaining the South's independence because they got to have cheap tobacco and cheap cotton, were actually going to come in on the side of the South. They were actually going to send weapons and munitions to support the South's efforts. And with the South, the Southern citizens knowing the South's territory, they actually would have been able to hold out, possibly even actually gain their independence. Abraham Lincoln was a very bright man, very smart. And yes, he was an abolitionist, so he did actually have an opposition to slavery. This wasn't something that was against his grain, so to speak. But he realized that if England came in on the side of the South, the North would lose, because England could draw upon all of Europe for munitions manufacturing. It didn't have to be whatever England had. It could draw on France, it could draw on Spain, it could draw on Germany, it could draw on any country and their munitions, bring it over and send it over. And with England backing, they would actually act as a spearhead for other countries to come in and back the independence of the South. But one weakness, the biggest weakness that England had, was they had been a slave-free country for 100 years and were very publicly advocates of abolitionism at that time, which abolition means, no slavery, outlawed slavery, speaking out for the freedom of slaves across the world, much like what America does today about going around the world and speaking out against political imprisonment, ironically while holding their own political prisoners. But much in the same context, that was England's position in the world. We are against slaves. We are going to oppose anybody. We're going to sanction anybody who supports slavery. And here they were going to support the independence of a country in the southern part of the United States, the Commonwealth of whatever you want to call it, whether it be the southern states, the Confederacy states, whatever you want to call it. The Confederate States of America, I believe, was the actual terminology they used at the time. But the point is, to keep them out of this, Abraham Lincoln came in and issued a proclamation, which is a proclamation, by the way, has no legal binding. It's not an executive order. It's not a law. It's nothing. It's just a statement. A statement made to the world in which he redefined that this war was being fought over slavery. That this law was being fought for the rights of individual men and women who were being held as slaves in the South. It absolutely was not true. It was not the reason for the war. It was not the reason why the South seceded. It was not the reason why the North was trying to regain the South. But by saying it was, he put England in a position to where they could no longer come in and support the South's independence, because if they were, they would be supporting the very institution they were very publicly outspoken against, slavery. It was designed to do, and it did exactly what it was designed to do, that was keep England out of the war. But it had absolutely no power. It did not free the slaves. It was not an order to free the slaves. In fact, we didn't get the freedom of the slaves until 2 amendments later, the 14th and 15th Amendment to the United States Constitution. So it actually had no power. It was just a really well-done statement to the world. And that's what this dissolution order was. It was a very well-crafted, very well thought out, looks good on the face, has zero power. It does not create a penalty for anyone to continue to enforce this standard, does not outlaw the standard, does not repeal the law, in no manner, shape, or form does it actually do anything to stop the practice of enforcing this standard. All it does is dissolve the very public face of their effort, the commission itself. It doesn't stop the practice, it doesn't stop the enforcement, it doesn't change the law. It doesn't change the fact that the judges are continuing allowed to use this law to abuse it in whatever they want to, or if the Montana Supreme Court's going to enforce it through their unpublished opinions. It's just a piece of paper that is very pretty to look at, looks like it's really good, looks like it's comprehensive, and all it's doing is saying, yep, we know what we're doing. We know exactly what we're doing, and we know exactly how far-ranging our abuse is. They're not actually going to do anything about it. They acknowledge it exists. What hubris. I know I'm a criminal. I know I'm stealing. I know I'm robbing. I know I'm hurting people's lives, destroying people's lives. I know. I know. That's all they basically are saying. I know and I admit it. It's a confession letter. And just to show you that we're serious about acknowledging that we know we're doing this, we're going to dissolve the public form that we use to enforce this standard. We're going to continue to enforce it, of course. We're just going to do it behind the scenes through our unpublished opinions. We're just not going to do publicly posted opinions through the commission itself. We're not going to now make a matter of public record what we're doing. We're not going to make a matter of publication what we're doing. We're just going to keep doing it behind the scenes. After this was done, they relegated enforcement of the standard officially to the Office of Consumer Protection here in Montana. They still enforce the same rules. Nothing has changed. The Commission on Practice was not only an unconstitutional body, it was absolutely, it was like a commission on the legality and the ethics of slavery. They knew exactly what they're doing wrong. They knew it. They didn't care. And when someone pointed it out and said, okay, we're going to bring in the federal government to look into it, they said, okay, well, let's dissolve the actual public entity that looks like it's the culprit. We're still going to do slavery. We're still going to enslave people. We're still going to put them to work. We're going to go over to Africa and steal them from their homes and whip them and put them in the cargo ships and haul them across like bales of barley across the ocean and sell them to slavery in the United States. We're just going to stop doing a very public committee on it. Well, that's what they did here. They basically stopped. They said, we're not going to stop doing what we're doing. We're going to keep doing exactly what we're doing. We're going to still do the very same things the FTC had issue with. We're just not going to do it publicly. And by not doing it publicly, the FTC looked away and they didn't even realize that they were just going to keep doing it. And by the way, I have made efforts to try to bring the FTC into this, and they've ignored me. So I don't know what's going on with that, or why, or who Jerry or whoever actually made the report actually spoke to, or whether they simply, my name is blackened by everything that Montana has done to me. They simply won't listen to me. Remember, as I said before, if you want to hide a political prisoner, call him a sex offender. Nobody listens to him. My record, the record they created, that they manufactured, may very well be the reason they don't listen to me. But nevertheless, I have tried. This is not the only illegal entity that exists under the Montana Supreme Court. The Sentence Review Division is a perfect example of another entity that exists. But I won't go too far into that, other than just to say that Montana Supreme Court created a Sentence Review Division that can review someone's sentence. They can either take time off your sentence, they can reinstate the sentence, or they can give you more time. It's just a separate body that after you've exhausted your appeals, you can go to them and say, hey, let's roll the dice and see if I get more time or less time. Completely unconstitutional. But that's another issue, for another time. I'm just saying that it's not the only practice that the Montana Supreme Court has done. It's not going to be the only one. It's just the one that got the one time we actually had the federal government looking into us, who got looking into the Great Montana Conspiracy, and they simply just shattered the committee that it was actually being looked into, the commission, and once they did, when the commission thought everything was fixed, they went away. That simple. But at the end of the day, the Commission on Unauthorized Practice lives on. It lives on in the practices of people within the Great Montana Conspiracy, within the Great Montana Conspiracy, within the agents, the officials, the officers of the state of Montana. They continue to enforce it. They continue to do it. Nothing has changed. The only thing that's changed is the method by which they do it. And they do it through unpublished opinions and memorandum orders. So now you have a very detailed and specific example of how and why these practices of unpublished opinions are so dangerous and so overreaching and so broad, and how they can cripple individual civil liberties and rights. With this one set of examples of issues they use these orders to enforce, you're denied access to court, you're denied access to doing things which you otherwise would be allowed to do under law. They restrict your constitutional voice. They restrict your ability to object to anyone or anything if they want to, because they've got a law that says they can. And the federal government, which is really the only agency that could actually do anything about this, whenever someone gets complaints, you call Washington, D.C., you call Utah, you call California, you place a complaint in an agency outside the state, they send it to the ground, the people on the ground in the state where it's occurring, which are the corrupted individuals that are part of the problem. If you care about America and you care about what's going on in Montana, and understand that what happens in Montana can happen anywhere, if it's allowed to happen here, it can happen anywhere. And you just need to get involved. As always, as I sign off here, I do want to remind you that, of course, this original broadcast is on Podbean. It's podbean.com. It's actually monspiracy.podbean.com. By all means, sign on there. Sign on to my YouTube channel. If you're watching it through any other source, keep in mind I do need to try to raise my subscribers on YouTube so that I can start soliciting for the promotional side of YouTube services, which would include putting these videos out for a broader spectrum and more of a random search capacity for people who are interested in this topic. As always, if you have any information about anyone who's suffered under Montana or anywhere else in the country but suffered from these kinds of conditions, by all means, contact me. If the person in question is in supervisory, control, prison, whatever, I can't speak with them directly. The conditions I'm held under and detained under as a political prisoner prevent it. However, Bill Russell's information is in the contact information that should be attached to this video. If not, by all means, go to Podbean. The information will be there. As always, if you have any ways to support us, whether it be through material donations, whether it be through financial donations, whatever else, I hate asking for resources and donations, but as I keep mentioning, I am using an iPhone to record this. I don't have a recording studio. I don't have the means to get it within my own means. If we want to improve our voice, if we want to be able to bring in and actually interview people, like, for instance, Jerry O'Neill, sitting across the table from me and actually interview him, it would require more than just one iPhone. It will require an actual video camera, the ability to record both of us at the same time, even a split screen interview process. By the way, and I've tried the split screen recording, and it just looks, it looks like this. It is small. So you see my face, and you see this itty bitty little bitty square in the lower right hand corner. Might be somebody you can't recognize who they are, but that's who they are. So you'd have to blow up the screen really big to see who that is we're actually interviewing. So it doesn't work on an iPhone to really do that effectively. So we need to be able to improve our resources and improve our ability to get our message out there. So if you have the ability to support us or help us in any manner, shape, or form, whether it be through purchase of my books online, go to ronglick.com, RONGLICK.com, buy any of my books. If you want the proceeds of any of my books besides my autobiography, which is U.S. Political Prisoner since 2004, please send me a note so I know to divert those resources away from my publishing efforts and into the support of this program. Thank you for your time, and as always, if at all possible, please be free. Thank you.